Yes, Mr Porter.
May it please my lords, my lady, I appear for the appellant with my learned friend Miss Carpasitis, and my learned friends Mr Vikram and Mr Weston appear for the respondent. Lord, just a word on timing, if I may, before I get into the substance of my submissions. When we sought permission, we thought our appeal would take 1 day. However, the court will have noted there is a respondent's notice that raises 4 additional points.
Yes.
So we agreed with my learned friends that we might require 1.5 days. For our part, we will aim to make our submissions, complete them certainly by lunchtime, hopefully a bit earlier today. My learned friend has indicated that he requires about 3 hours. So with luck and a fair wind, we should be on our reply by lunchtime tomorrow. We understand that the court can give us some time this morning, and then
yes,
not
we need to stop by 1 o'clock today.
Yes.
And then we'll have a day starting at 10 o'clock again tomorrow.
Yes.
And it may be that by the end of today, you're in the position of not necessarily sitting down, but say you'll think about things overnight. But we'll see how we go.
Of course, my lord. Thank you. My lord, at the back of the court is our Mr and Mrs Karpasitis.
Yes.
In the far corner. My lord, as is apparent, I think, from the papers and as recorded by the learned deputy judge, Mr Karpasitis suffered a fracture of the spine at the level C2, which has led to continuing disability and loss of his job as a social worker. This is all a consequence of a fall from his bicycle on the evening of the 22nd of April 2020. Lord, this was an avoidable accident. It wouldn't have occurred if the hole had been filled or guarded before that time. And secondly, it would not have occurred if the appellant had not believed that the path he was cycling on, reasonably believed that the path that he was cycling on was a path for cyclists. Lord, I'll set the scene, if I may, very briefly by reference to our skeleton argument, which is in the core bundle C. And, well, before I go to the skeleton argument, perhaps I'll take you to the defendant's own map, which is in supplementary bundle A, tab 3. Your Lordship will see that this document, which runs to 2 pages and then there's a blow up on the 3rd page, it's small print because of the way in which it's been reproduced. It's plainly produced by the respondent county council in the laudable effort to encourage people to cycle around their county. The blue routes are described as a great traffic-free choice, and dotted blue is a recommended link. My lord, that's clearer on the 3rd page because it's been blown up than it is on the 1st page where it's in very small print. But on that 3rd page at A31, the blow up from A30, your lordships will see that there is a dotted blue link that runs from over the M25 at the bottom left of that blow up, and then up the A10. The writing is rather obscured by the blue dots, but that reads underneath there, the Great Cambridge Road. And that is essentially the path that was being taken by the appellant. Firstly north and then south again, before he encountered the hole in the verge and suffered his unfortunate accident. The respondent's highways department were, at the outset of the trial, unaware of this map, or at least I hope they were unaware of this map because they hadn't disclosed it to us. It was found during the course of trial due to the industry of my instructing solicitor. And it is a illustration of how easy it is to mistake what the judge found to be a footpath reserved for pedestrians to be a shared path shared by pedestrians and cyclists. Well, turning now to our skeleton argument, as I said I might. This is core bundle tab 5. We try to describe the scene a bit further, page 40. It is quite a complicated arrangement. Your Lordship will see that the extract from Google Earth, which was in fact extracted by the respondent's expert in the case, shows a bridge, a pedestrian and cyclist bridge called the Paul Cully Bridge. And it's not that easy to see that it's clear from ground level, and it's common ground between the parties, that south of that Paul Cully Bridge, the route travelling north alongside and to the right, that is to say the east of the A10 dual carriageway, is a shared use path shared between pedestrians and cyclists.
Well, I didn't
My Lord,
find
if
this photo very useful, I'm afraid. I don't understand it. Is the same thing shown more clearly somewhere else?
we tried to extract some photographs to try and show it a bit more clearly over the page 41. That is just to give a very bird's eye view, if you like, of the background. If you were, just before I leave that map, though, if you were to leave the northbound shared path, wishing to go anywhere other than to continue north alongside the A10, or to go up the sets of flights of stairs up to the Port Cully Bridge, you would need to leave the path some way south of the bridge and come out where you could just see the path coming out between the trees and hitting the path that goes over the bridge just above geo information. You'll see that. And I'll try and make it a bit clearer by reference to the other photographs that we've extracted from experts' reports over the page. If you carry on underneath the Paul Cully Bridge and you're heading north, you get to the point which is shown in the first of the photographs at the top of page 41 in our skeleton argument, where the path narrows. There's no signage for cyclists who intend to carry on north alongside the A10. There is a sign if you were to turn sharp right at the point where the path narrows. Your Lordship see on the second photograph at the top of page 41, there is, slightly incongruously, a shared use sign, that is to say with the cycler and pedestrians underneath, and the instruction cyclists dismount. So that applies if you make a sharp right turn.
Where is that on page 40 photo?
That is just north of the Paul Cully Bridge. And I'm afraid it's
are
not
we
come out
looking
terribly clearly. But we'll be looking at the area. Can your Lordship just make out some flights of steps intended for pedestrians to the going up to the bridge? We'll look at them from another angle in a moment. But that is the flight of steps that's seen at the top of page 41. So if you were to go up those steps, probably more likely as a pedestrian than as a cyclist, you would turn sharp right at the point where the path narrows, and you would head up those stairs. You get onto the bridge now.
I don't know whether this matters, Mr. Porter, but I can't see the steps.
No. Well, no. I mean, I understand your difficulty. If one goes online to Google Maps, one can zoom in and see it a bit more clearly, perhaps. But does your Lordship see that there is a southbound vehicle that's just passed underneath the Portcully Bridge. And just to the right of that, one can see that there's a protrusion from the path, which is in fact those steps.
Well, I'm
Because
afraid
they
not,
obviously, the
but
steps obviously run at right angles.
If this is going to be important, could somebody in your team produce a magnified version of the photos on page 40 and 41? It may be that it isn't important.
Well,
I like to understand what is being said to me.
yes.
I can't see
I don't know
it.
if Fred's going to suggest a better version.
Oh,
my learned
right,
friends
yes.
helpfully
I
suggest
don't
we
know where
might
it
turn
is.
to page A94.
Yes. 94 of which
Bundle A.
Yep.
Which comes from one of his Mr. Alan Smith.
Oh, right. It's much better.
It is clear. I'm sure I think it's possibly the quality of reproduction in our
Yes.
skeleton has not gone as well as we hoped it would, because I think it's actually exactly the same picture. But it's annotated by Mr. Alan Smith. There is the Portcully Bridge. I hope your lordship can see it a little more clearly.
Yes.
There is that vehicle going under the bridge, southbound, and to the right as we look at that, so that is to say to the east, you can see a bit more clearly that sticking out from the path, right angles to the path, and then doing a 180-degree turn, are the steps that are the only alternative once you've reached the narrowing of the path just north of that Portcully Bridge. And this does make also the alternative path somewhat easier. If you have continued a bit beyond that junction, which is halfway between the Portcully Bridge and Theobald's Lane, then there is an unmarked way of turning right at that point through the trees and going up to the path that leads up onto the bridge.
Yes.
Does that make it all a little clearer?
Yes.
It's a complex layout, and it should have received rather more consideration when it was built than it did.
Yes.
Because if you go past that turn that I just indicated, there is nowhere to go other than either straight on up the A10, continuing up the path, or, which is something one would almost certainly not wish to do with a bicycle, you would have to turn onto those steps past the cyclist dismount sign. But the cyclist dismount sign only applies to those turning right and going up the steps, and not to those going straight on.
And where would on page 94?
Yes.
Where is the cyclist dismount sign?
It is at right angles to the
Yes.
path if you do the right turn. Unfortunately, it's just not enough. You could do a bit more of a sort of eye-fish view of the photograph at the top of our page 41. Is that is if your lordship can imagine
It's just
the
off
path, the path running at right angles to this short section here. The main path runs this way, at right angles to that. And then the cyclist dismount sign is set back behind this fence and applies to those who've chosen to turn right. I don't suppose there are many cyclists who would attempt those steps without dismounting, but that's as it is. There's nothing, as your lordship will see, there's nothing for those from the photograph to the left of that, on the top of our page 41. There's nothing to indicate to a cyclist at the point where the path narrows that it isn't entirely legitimate to carry on north. Well, it may help finally trying to set the scene if we, again in bundle A, at tab 7, is the witness statement of the appellant's father. Page 49. You can see a bit of a view as to how that relates to where the hole was, the hole in the verge. Your Lordship see that someone has circled in red the hole. This is obviously looking south, with the main vehicle carriageway of the A10 to the photographer's right, and the path that was being used by the appellant at the time of the accident to the left, and you can see the steps that lead up to the Paul Cully Bridge in the background.
Yes.
That makes it slightly clearer what the context is and where we are in relation to that bridge.
Yes.
As for the hole itself, finally, best seen in tab 16, photographs taken by appellant's expert, Mr Kettridge, page 143.
Yes.
He takes these photographs on the 19th of May 2020, before the hole is rather mysteriously filled in circumstances that the learned judge wasn't able to come to any conclusions on. That's as it were by the by. This is the hole. Mr Kettridge has put his measuring stick both across and into the hole, and I don't think there's any dispute that at least at the time that Mr Kettridge inspected, the hole was 0.8 metres by 0.7 metres. He has those dimensions towards the bottom of the page. And the depth of the hole was 0.55 metres. It's just over half a metre deep. So it was a very substantial hole. And unfortunately, rugged though the bicycle that the appellant was riding was, obviously he couldn't cope when his whole front wheel disappeared into that substantial hole, and rather inevitably he came off. So Lord, I hope that reason, as it were, sets the scene.
Yes, it does.
By permission of Lord Justice Mayles, we appeal on two grounds against the judgment of the learned deputy judge. Firstly, that the judge was wrong to find that the respondent highway authority had satisfied the burden it has of proving the special defence pursuant to section 58 of the Highways Act. And secondly, that the judge was wrong to find that in the particular circumstances of this case, there was no duty of common law on the respondents to indicate to users of their highway that their cycle path did not extend more than a short distance to the north of the Paul Cully Bridge. And that is because it gives every appearance of so extending. Well, as I've mentioned, the respondents also appear dissatisfied with the judgment below, in the sense that they've raised the 4 points that I've mentioned in their respondent's notice. And, well, I hope it assists. We've set out in writing what we say about those points, and it's tab 4 of our core bundle. And it's worth adding at the very outset that neither party is happy about the delay in the production of the judgment. We finished the trial with oral submissions on the 23rd of March 2023. After some 4 months, the judge appears to have forgotten what some of the submissions we made to him were, particularly in relation to a document I'm going to come to with some timings on it, and asked for further written submissions, and then supplied his judgment approximately 3 months after that. And well, we don't shy away from saying that the quality of the judge's decision-making appears to have been affected by this unacceptably long delay. But also, lady, the success of the defendant in its Section 58 defence relied upon the written evidence of one Mr Cook, a highways inspector employed by the respondent's contractors Ringway. Lord, I propose to divide my time with my learned junior, Ms Carsters. She did not appear below, and is accordingly in a good position to be a little more dispassionate and objective about the point which the respondent made successfully before the judge, that I had been, as as I see it, somewhat manoeuvred into binding my client in the court for the truth of the whole of the statement of Mr Cook. That's the point he raised successfully before the judge. He raises again in his skeleton argument. We don't accept that. My learned junior can perhaps be a bit more dispassionate than I can about explaining why not. But before we get there, can I make some observations, starting with section 58 and Mr Cook's evidence? It's important, of course, to look at what he says and how the respondent's case, certainly as we saw it on this side of the court, shifted from relying on Mr Cook as their star witness for a section 58 defence, and then at trial disavowing him and relying on an alternative defence that there was no actionable defect, so that section 41 was not engaged. That was a definite shift as we saw it in the defence's strategy below. Mr Cook's statement is in bundle A, tab 14. The Lordship will see it's dated the 10th of June 2022. He deals with the inspection that he says he conducted on the 13th of February 2020. He does indicate, paragraph 3 of his statement, page 114, that it was a walked, scheduled inspection of both the footpath and the adjacent grass verge. He indicates in general terms how he would have set about doing that inspection. Importantly, over the page, page 115, paragraph 7, he states that had there been a hole of any description present on the grass verge in the accident location during my last walk inspection on the 13th of February, I would have recorded it on my handheld tablet. He goes further at the end of paragraph 8, so based on the claimant's photograph, which Mr Cook wasn't there to ask, but I anticipate is the photograph that Mr Kettridge took that I've taken the court to. Based on the claimant's photograph, I would not have missed or overlooked such an obvious and glaring defect. Paragraph 9, I would have arranged for a metal footway plate to be placed over the hole. After I'd arranged to make the area safe with the footway plate, I would have reported the matter to the Ringway Local Network. And then in paragraph 10, he repeats, had I seen a defect of the type shown in the claimant's photograph during the scheduled inspection on the 13th of February, I would have recorded on my handheld tablet words to the effect of casualty 1, 24-hour, sunken grass verge, please make safe with appropriate footplate. Paragraph 14, it may be worth noting while we're on his statement that he's indicated it would take him about 10 minutes to walk a stretch of footpath that's relevant to this accident. Paragraph 16, we can see that the statement was taken during two telephone discussions with Mr Simon Johnson, first on the 22nd of October. The second, which I invite the court to note, is on the 10th of June 2022. So that is, I don't know if the court turn to the very end of the bundle A, that is in the context of Mr Johnson on the 18th of May 2022 having disclosed a document which we will have to come to in due course with timings apparently on it. Mr Johnson indicates in the penultimate paragraph, although this will be covered in the statement of Jeff Cook, the inspector who performed the last inspection for the accident, the vehicle tracking data relates to the Ringway vehicle he drove in to get to the walked inspection route. For the avoidance of doubt, Mr Cook will also give evidence about the duration of the walked inspection, start and end points. So we note that some 3 weeks after the disclosure of that document and the email from Mr Johnson, the respondent solicitor, to my instructing solicitor, he is having a telephone discussion with Mr Cook. There is no mention in Mr Cook's statement, no mention or explanation of the document we're going to look at with the timings impressed
Sorry,
on it.
no mention of...
Of the document with the timings impressed on it that forms an important part of this appeal, which we will have to come to shortly. But to make good my assertion, claim the defendant's case below changed dramatically, I refer very briefly to the rest of the served lay evidence, or in particular to the served evidence from a Mr Vine and a Mr Alan Smith. Mr Vine is at tab 13. At page 111, Mr Vine provides, paragraph 5, character reference, as it were, to Mr Cook, who he regards, in the middle of the paragraph, regards as one of, if not the most experienced and capable highways inspectors employed by Ringway, wouldn't have any concern about the manner in which he performed his job, etc. Very experienced, understood the requirements. Jeff knew when to intervene and raise a works order. Equally, Mr Alan Smith, likewise, this is tab 12. Page 83 in the statement. He too expresses confidence in the judgment of Mr Cook, particularly paragraph 11. He refers 6 lines into that paragraph. Based on the record of inspection for 13th February 2020, no defect identified. I'm aware that Jeff is retired from Ringway. He was regarded as a very capable, conscientious, diligent and experienced highways inspector. Having come across him in the past, he struck me as an inspector who was able to properly risk assess defects and determine whether a repair was required, and he was able to distinguish between a category 1 and a category 2 defect. As matters turned out at trial, once the defendant decided not to rely on the civil evidence act notice they'd served in relation to Mr Cook's evidence, both Mr Vine and Mr Alan Smith gave evidence to the judge that they would not expect a highways inspector to categorise the defect in the verge as category 1. They would expect it to be categorised as non-urgent category 2. This is how we got into the whole debate about what we could do or not do with Mr Cook's served statement.
I'm wondering,
yes.
Mr Porter, why that evidence was admissible in the first place.
His evidence as to whether it was a category 1 or category 2.
Well, why were these two people in a position to second guess what a highways inspector would have done if they'd looked at it and how they would have categorised it? They're not experts.
No. Well, it's a very good point.
Did you object to those questions being asked on the basis that that evidence was inadmissible?
Milady, no, I didn't object to it. Perhaps I should have done. But they claimed to have known him and known that he was good at his job. The genesis of the ideas, Mr Hopwood was the respondent's expert at trial, and it was his idea, essentially, that this would be categorised properly as category 2 rather than category 1.
Yes.
One can see that from not many weeks after the service of the lay witness evidence. Mr Hopwood, who's at tab 18, we don't have the whole of his report because care was taken not to put unnecessary material before the court, but Mr Hopwood quoted extensively from Mr Cook's statement about the inspection, but chose not to quote at all from the passages I've just highlighted about what he would have done if that hole had been present. My lady will see at paragraph 6.3 at 169 that it was his evidence that defects that occur in grass verges are generally not considered by most UK highway authorities to be category 1 dangerous defects. And the witnesses to whom I've just referred were rather, as we saw it, jumped onto that. So, well, we're not now calling the highways inspector. We're going to contradict his evidence about what we expected him to do. And it was in those circumstances that I considered it advisable to seek to take the judge to Mr. Cook's statement. First, I tried to persuade the judge to let me refer to it when cross-examining witnesses. Second, I asked him to admit the parts of it that I wanted. And finally, I agreed that the whole statement would go in as it were for context, but it was expressly on the basis that we were not bound by the whole of it. But in his final submissions, my learned friend referred the court to some cases that my learned junior was going to take the court to, indicating that by acting as I did, I had bound my client to accept that a walked inspection had taken place in February.
None
Well,
of that.
if that was right, you've thrown away your whole case
Yes,
on that.
to save my embarrassment, my learned junior.
Not much point carrying on with the trial, I would have thought, after that.
Well, I had a secondary argument, which was about failure to signpost the end of the cycle route, so I've carried on that basis.
The judge doesn't seem to have given a ruling, but this is something on which Ms. Karpasitis can address us in due course. But the application you made was that two witnesses, Mr. Alan Smith and Mr. Vine, had said, I would have expected Mr. Cook to have categorised this as category 2. And you sought to put to them, well, the question you want, the series of questions you wanted to ask, I imagine would have begun with, have you seen Mr. Smith's signed statement, backed by a statement of truth, saying that he would have categorised it as category 1? And you were not allowed to put that question.
Yes.
At the moment, subject to further argument, I find that astonishing.
Yes.
All right.
Well, he was definitely giving a very firm indication he was not going to look at that statement unless I put it in evidence. And he was fortified in that by the submissions of my...
Well, that's where it all started to unravel.
Yeah.
Because there's a
Well,
world, a world of difference, Mr. Porter, between attacking the credibility of a particular piece of evidence, which, leaving aside whether they're competent to give it or not, is controverted by evidence from the very person whose mind they're trying to read, and the rules of procedure which say that if you want to rely on the other side's witness, you've got to put the whole thing in. Because you only got to that stage because you weren't allowed to cross-examine on the credibility issue.
Indeed.
And I think it's mixing up two different concepts.
Yes. Well, it was difficult to get a formal ruling from the learned deputy judge on more or less anything, but he made it very clear with his indications during the course of argument that he was not going to look at that statement unless I put it in evidence.
Right.
Well, I think the court has the point that there was. I'm afraid because of the delay, the learned judge appears to have forgotten that Mr. Vine and Mr. Smith had changed their tack trial, and he uses expressions we've pointed out in our skeleton argument. He uses expressions like it was appropriate for them to continue to maintain that this was a category defect. Well, they hadn't maintained it until the trial itself.
And on that point, namely whether it was a category 1 or category 2 defect, the judge's conclusion was
that it was an urgent defect anyway.
it was a category 1 defect.
Yes.
So you won on that.
I did eventually win on it,
So,
but I'm now explaining
in the
why.
judgment, you won on that.
I did indeed.
So,
Yes.
so it's there are lots of things about this case that are all a bit tangential and indirect. I'm just having trouble translating it to the result.
Yes.
Anyway, you say
Well, I won on the point. I see my learned friends getting interested. I won on the point it was an urgent defect that should have been remedied urgently.
Right.
Can I correct that, please, with my learned friend's permission? The judge found it was a category 2 defect and non-urgent, but nonetheless was dangerous.
But nonetheless,
Was dangerous for the purposes of Section 41 of the Highways Act.
This is as at 13th February, or as at the date of the accident.
As at the date of the accident, he found that it hadn't been present on the 13th of February. I can give the court the references in the judgment that are dismissed.
No, it's all right.
Lord, we're here in due course why this is thought to be an important distinction, but I won on the point that this was an actionable defect engaging Section 41. So, had it not been for the success of Section 58, the claimant would have been entitled to succeed below.
Well, it may matter, Mr Porter, because if what Mr Waxman has said is accurate, and I've no reason to suppose it isn't, the judge accepted it was Cat 2, dangerous or not dangerous. And the only evidence that it was Cat 2 was the expert that you've taken us to, plus these two witnesses who, as you put it, jumped on the bandwagon at trial. He might, however, have taken a different view had he known that the man who claimed to have done the inspection would have categorised it as Category 1, and that had been put to those witnesses, and they had said, well, if that's what he says, we agree.
Yes. My lady, I gratefully adopt that. I respectfully agree. I'm just looking precisely to what his ultimate conclusion at paragraph 126. Core bundle, tab 9 is the judgment. Page 109 is the particular passage.
So,
And I'm not
sorry,
sure,
Mr. Porter, let me
as
catch
with
up.
many matters, I'm not sure the judge was entirely clear about this.
Which paragraph?
Paragraph 126. He relies on the fact, just to go up to subparagraph 4 at the top, towards the top of that, 109 in court. He does rely on the fact that both Mr Cook, the highway inspector, and Mr Martin, contract manager of grass cutting, both clear that if there was a substantial hole present on the 22nd of April, it would be category 1 and had to be repaired quickly. Then he says, 125, having referred to that, he says, I find on the specific facts of this case, stepping onto or cycling onto the grass verge is normal use of the highway. The public have a reasonable expectation that substantial holes in such verge would be repaired within a reasonable period of their discovery. Such substantial holes constitute the sort of danger which an authority may reasonably be expected to guard against. I do not accept, this had been one of my own friend's arguments below, I do not accept that this finding would place an unrealistic or disproportionate burden on highway authorities' limited resources, and in all the circumstances, clear conclusion of 126, the defect was dangerous as of the 22nd of April 2020. So whatever words he used, he found it was a dangerous defect as of the date of the inspection by our highways engineer. Well, I won't dwell on my embarrassment, as it were, in the court below, because my learned junior is going to very kindly agree to deal with that. But I will now take you to the principal reason, as we set it out in our skeleton, to reject Mr Cook's evidence as related to a walked inspection. And that is the curious but key document, which is at bundle A, tab 4. Page 32. We know from Mr Johnson's email, which I took the court to a moment ago, it's the very end of that bundle, that this document came from Ringway. And we know that it represents data from Mr Cook's vehicle, as that's what Ringway told Mr Johnson and what he told us when disclosing that document. Lords and Lady, there's clearly some underlying data behind this document, but Ringway have chosen not to supply it. It's been over 2 years since I submitted to the Deputy Judge what the document plainly appears to indicate, but we've never been supplied with any explanation as to why we might be wrong or any background data despite requests for such data. The respondents have simply said that it's not 100% accurate and you cannot contradict your own witness, which is the point they succeeded on before the learned Deputy Judge.
Well, as to the first point, that's what Ringway told them from
Mr.
that
Johnson,
last
yes.
email
Yes, indeed.
at page 209, because there's a quote, isn't there? Please see Jeff's vehicle data attached for that day. The data shows that Jeff was on site. It doesn't show where he stopped and for how long. Unfortunately, the tracking data is not 100% accurate,
Yes,
as it does rely on pings from satellites similar to our phone.
yes. We've never had more than that.
No.
I think we all know we can take photographs of our phones and get perfectly accurate timings attached to them. So if it operates like a mobile phone, as Ringway have suggested, it's difficult to see why there would be any substantial inaccuracy in these timings. We know, I think, in the absence of any contradiction, that the vehicle driven by Mr Cook that day sets out from point A, which is in green, and finishes at the local authority depot, which is at point B in red. Those who set up this system, that's for understandable reasons, clearly want to know that their employee is using a direct route, so that is why calculated in the left-hand column, you see that the actual distance that vehicle has travelled is 5.1 miles with a driving duration of 33 minutes, whereas the direct route between A and B would be 1.2 miles with a duration of 4 minutes. So the actual is tracked in green, as we understand it, as being the 5.1 miles, and goes past the accident location, which is on the A10 between the turn-off for Cheshunt, which we can see is the B198, and the roundabout at Winston Churchill Way. The Portcully Bridge is unfortunately not shown, but it's somewhere between those 2 points, and so Mr Cook did appear to drive past the scene of the accident. The 3 intermediate addresses that are listed on the left-hand side of the page very much appear to be stops for the vehicle. And they're presumably these stops where the engine is off rather than stopping at a junction or a traffic light or the like. So we have particular times, which we certainly think could be nothing other than stops. And we have in brackets after the times figures that can only be the period of time for which the vehicle was stopped. So that being the obvious inference from this document, the first, he sets off from 11 Priory Gate, which is a residential area, may or may not be his home address. We could have asked him about that had he given evidence. He stops almost immediately, just next door, 11 Priory Gate to 12 Priory Gate. He stops there, it appears for 7 minutes. And then his next stop is very close by, still in the north part of Cheshunt, and he stops there for, it appears, some 2 minutes. And then it appears that he stops at the Great Cambridge Road, the A10. That's the road alongside our cycle path is. And it appears that he stops there at 10:17 for 3 minutes.
Where?
Somewhere on the Great Cambridge Road, A10. So, well, the very simple point, which I'm afraid had been forgotten by the learned judge, or dismissed incorrectly by the learned deputy judge, was that these timings were not consistent with stopping at the A10 in the vicinity of the footpath, walking down it for a period of around 10 minutes, walking back up, almost certainly on the other side of the road, because we know that there was an inspection of the footpath on the other side of the road on the same day, returning to his vehicle, and driving back to the middle of, driving back to point B, which is just north of Cheshunt. So it is most basic. He's at a point just north of Cheshunt at 10:06, almost certainly. Might conceivably be 10:04, but as we interpret this, at 10:04 he stops for 2 minutes, so he leaves at 10:06. And he's back in Cheshunt at 10:26, back at 50 High Street, Cheshunt. An interval of just 20 minutes. So even without the inevitable driving time, he simply does not have time to walk down the footpath, come back, as I say, probably the other side of the A10, as we pointed out in the more detailed submissions we submitted to the learned deputy judge, get back to his vehicle, complete the inspection report, get back to his destination in Cheshunt. Well, of course, this is not our document. It's one that the respondents obtained from their contractors. They haven't had any problem getting documentation from their contractors that assists them at trial in the form of highways inspection reports and the like. It's very telling that they made no effort whatever to explain how an inspection, walked inspection, could have taken place, how these timings could possibly be interpreted to include a 20-minute walk. They simply say, not 100% accurate, rely on pings from the vehicle, and we respectfully submit that's plainly not good enough.
So you say that apart from messing around in Cheshunt, which is not relevant for present purposes,
Yes.
This document appears to show that Mr Cook's vehicle left Cheshunt at 10:04.
More likely 10:06.
Oh, sorry, 10:06. And in the ensuing 20 minutes, only stopped once for 3 minutes.
Oh, yes.
So had Mr Cook attended the trial, you would have wished to put to him, you didn't carry out a walk inspection at all, did you?
Not walked, anyway, Lord. It's possible he did an inspection of the footpath from the vehicle.
Yes.
That, as I think was common ground, wouldn't have been good enough, and he purported to have done a walked inspection. Now, he might, of course, have forgotten after a stretch of time which walked inspections he was supposed to do that he in fact did by car, and which ones he actually did by foot. So, but it's interesting that he was plainly presented with this map at the time that he finalised his witness statement, and yet there's no comment in it, despite Mr Johnson's indication to us that Mr Cook would explain matters. Well, I made submissions in some detail.
And you get to that because you point to the last document and the date, which was the 18th, was it? Yes, 18th of May.
Yes.
And then you point to the fact that there was a further conversation referred to in the Cook witness statement subsequent to that date. Mr Johnson said Mr Cook would deal with it in his statement, but he doesn't.
Correct.
Those are the,
It's only a matter of 3 weeks after the email. And
those are the building blocks for that.
Yes.
Yeah.
I'm afraid, because of the passage of time, the learned judge simply forgot the quite detailed submissions I made before him, the closing submissions about this document. Either that or he didn't understand the submissions I made, because he just dismissed it. My submission, he was plainly wrong to do so. And he'd plainly forgotten my submissions, because he asked 4 months.
Just wait.
Yeah, I'm so sorry.
Stop. Yes.
He asked, as I've indicated, 4 months later, he had a message sent to the parties, please tell me what your submissions are on this document. So at that point, we thought, well, we better give him, it was looked at and examined from every possible angle in the further submissions that we supplied. concluding that Mr Cook had not possibly done the walked inspection and the drive to and from the A10 in the time that he said. But my lord, the basic point is quite a simple one. This requires explanation. The only stop on the Great Kent Road is said to be at 10:17 for a total period of 3 minutes. That might be, there's no evidence on this, but that might of course be because he stopped to make his entry on his handheld computer that he refers to, which we know he made because it generated an inspection report. That is timed at 10:16, which is just before the stop at 10:17. And as I admittedly speculated a moment ago, these stops are not every time the vehicle gets to 0 miles an hour. It's probably when the engine's turned off. So this is February, he stopped somewhere, he's done his report, timed at 10:16. He turns his engine off at 10:17 for some reason, for 3 minutes, plainly not long enough to do any kind of inspection, and then heads back to 50 High Street, Cheshunt, arriving back there at 10:26. So, my lord, that inspection report, for your lordship's note, is in bundle A, page 122. Again, it's plainly a secondary document, as it were, taken from data which has been put onto the handheld device. The court will see that dated at the top, 13th of February 2020 at 10:16:11 seconds. Now, one doesn't know, one point made by the learned judge, one doesn't know if my speculation that he had the engine running at 10:16 just before he turned it off at 10:17 is admittedly on my part speculation. And one doesn't know if these two clocks were precisely synced, although the likelihood surely is that if they were connected to satellites, they would have been accurate. But even if, as the learned judge thought was a possibility, these were different clocks on different times, one can at least expect that the timings on the document at A32 are internally consistent. So if they're a minute out, there will be a minute out, or if this is a minute out, it doesn't matter in precise relationship to this. Within a minute of each other, within a minute of the stop recorded on the document at A32, there is an entry made at A122 purporting to have done an inspection. And at this point, it's only fair to Mr Cook, I think, to point out, he doesn't claim in that document that it was a walked inspection. And the overwhelming probability is that it wasn't a walked inspection, it was at best a driven inspection. So, Lord, to say this requires explanation is serious understatement when it is entirely what underpins the respondent's Section 58 defence.
Are you leaving A122?
My Lord, yes, I think so.
Can I just ask you this? I noticed, obviously it's a relatively short document, and it's obviously a pro forma, but I couldn't help noticing it said verge damage.
Yes, my Lord, yes, that was explored at trial, and it was explained by Mr Cook as being damage done by overrunning lorries.
Explained by?
Sorry. Maybe he did explain to somebody at the trial, it may have been Mr Alan Smith, explained that was overrunning lorries rather than the big hole that Mr Cook says would have been covered by a plate.
Well, it's clearly
protected.
What is absolutely clear is that if and insofar as Mr Cook carried out an inspection on the 13th of February, he did not notice the hole in question.
Yes, precisely. And that's what underpins, whatever the judge says about it, that's what underpins the learned deputy judge's finding that the hole was not there on the date of the inspection because he accepted Mr Cook's evidence as to a warped inspection.
Right.
So, as we said in our skeleton argument, we'll go back to that, page 47 in the core bundle. We say this state of affairs would have been bad enough if we got a judgment within 3 months, as parties are generally entitled to expect. It's made very much worse by the substantial delay between the trial and the judgment, and some citations of a couple of cases, paragraph 25 on core bundle, page 47. In our skeleton argument, there's the Archangel Sky case, which we have at tab 21 in our bundle of authorities. Very happy to take the court to that, if thought desirable. That is, that this court reiterated the importance of parties receiving judgments within a reasonable period of time. I doubt that's terribly contentious, and I think my learned friend will probably join with me in deprecating the delay we experienced in this case. And we set out actually in our skeleton what is clear from the Chancellor in paragraph 84 of his judgment. The 3-month general rule should be adhered to even in long and complex cases, and arguably this was not a long and complex case. We occupied the time of the court for 3 days with evidence. We're entitled to receive judgments within a reasonably short period of time, no longer than 3 months. Any other approach will lead to loss of public and business confidence. And the passage in the Goose case from Lord Justice Peter Gibson, the Goose case is at Authorities tab 6, but is cited by Sir Geoffrey Voss. That's one ought to just turn reasonably briefly to this, because I don't imagine there's any real dispute that this sort of delay is undesirable and had undesirable effects.
Quotations in your skeleton argument from Archangelski case and Coulson and Sanford are accurate as I think they are. You don't have to go to the primary source.
Look, I'm grateful. They're there if your lordship needs it in the bundle of authorities, but I'm anxious not to waste any time that can be more suitably employed otherwise. So that's where we are on delay. There were, I respectfully submit, some confusing passages in the judgment about making findings that the whole was not there on the 13th of February, avowedly without Mr Cook's evidence, yes, which makes no sense, as the only relevance of the date, 13th of February, is that that's when Mr Cook says he undertook his ward inspection. If he did not, my primary submission is that date of the 13th of February becomes irrelevant, and the Section 58 defence simply fails.
I mean, it is certainly right, isn't it, that the judge endeavoured to make those findings without reference to Mr Cook's statement, at least as I read it.
Yeah.
So paragraph 108, for example, when he finds there was no significant hole in the grass verge,
yes.
So, and he does that effectively by reference to expert evidence.
Yes.
But the difficulty that I had with this, and it may be my fault entirely, but the difficulty I had with this is he kept coming back to the 13th of February and the inspection.
Yes.
So it only really makes sense if you have a starting point that there was an inspection on the 13th of February.
Yes. Which
came from Mr Cook. So, there is the contemporaneous record, which he refers to at paragraph 138
yes.
in the judgment.
Yes.
But so your point is just that, is it, that despite the judge's best efforts to distance himself from Mr Cook's statement, none of it makes sense without that starting point.
No. My Lord, precisely, the Lordship has my submission, puts it better than I could, but the learned Deputy Judge plainly thought this contemporaneous document was of some importance. He refers to it not just at paragraph 138, which I think is the passage my Lord just took me to, but also somewhat earlier, paragraph 73 in his judgment. This is page 97.
Yeah.
Where he's striving to make a finding on this point without Mr Cook's evidence, but he says even without Mr Cook's witness statement, there is the contemporaneous evidence of his inspection, which found no defect in the grass verge. So he's going straight back.
Sorry,
inspection.
Where's that?
I'm sorry, that's paragraph 73 of the judgment, which is page 97 in the court bundle one.
And that must be the document we've
That's the
just
document
looked
at
at.
page 122, bundle A, which is generated by Mr Cook. And as I say, in fair to Mr Cook, he doesn't even confirm in that document that he's done a walked inspection. So he relies on that twice. I mean, there are indications that perhaps the learned judge came back to this judgment on a number of occasions, because having set it out at 73, he then sets it out again at paragraph 138. Almost saying exactly the same thing. 138, leaving aside Mr Cook's witness statement as contemporaneous documentary evidence. An inspection was performed which did not detect a hole. Refers to it there as persuasive evidence that an inspection was performed on the 13th of February and no hole was found. Well, of course it isn't, because it comes directly from the same witness, Mr Cook. And furthermore, this is a point which obviously didn't find favour with the learned judge, but it's a valid point. The content of the form at A122 was an exact reproduction of the inspection made around 6 months earlier, which is the preceding page at 121. So it's not terribly convincing that because those defects of uneven footway and verge damage are recorded at page A122, not a very clear indication of a careful inspection. It's simply a cut and paste from his previous effort on the 16th of August 2019. And then the other point that the learned judge appeared to have thought was important was from the expert evidence. But again, that's misconceived, because as the learned judge correctly set out in his judgment, page 102 in the court bundle, this is his summary. There are a large number of subparagraphs, but for context, beginning of paragraph 83, this is his summary of the evidence of Mr Michael Hopwood.
Sorry, just give me the paragraph.
Yes, I'm going to subparagraph 25, page 102, which is part of, I was just trying to put it in context, it's part of his detailed summary of the evidence of the defendant's highways engineer, the expert, Mr Hopwood. So he is a reference, therefore, to Mr Hopwood. The prime reason that he, Mr Hopwood, thought it very likely that the whole depression was not present on the 13th of February and developed shortly before the accident was that A, Mr Cook was a very experienced safety inspector, and he would have had a clear and unobstructed view of the verge. Grass on the verge would be likely not to be particularly long. It would have been very early in the growing season, and he would have been no more than 1.5 metres from the hole, assuming he walked in the middle of the footway, there was no reason why Mr. Cook would have missed such a relatively large hole in the verge. So it's only because Mr. Hopwood is scratching his head and thinking, well, how did such a massive hole appear in the relatively short interval between the 13th of February 2020 and the 22nd of April 2020. He starts with the premise that there must be some explanation for it. So he diverts himself away from the explanation that this is connected with the removal of a tree some years earlier, and towards the actions about which he had little, if any, expertise, the actions of burrowing animals. So, C, which is paragraph C of 25, again, this is the opinion of Mr. Hopwood. The cause of the hole has been established to be burrowing animals and or underground rotting tree stumps. And that it's likely the ground underneath the verge could have simply collapsed very suddenly. So all these things that Mr. Hopwood said, well, this could have happened, that could have happened. And that explains why a hole that wasn't seen by Mr. Cook in February is such a large hole in April. And that is in turn heavily reliant, obviously, on the inspection said to have taken place in February. So if the inspection takes place, the expert evidence is not going to solve this particular mystery.
Miss, you've told us, as is evident, that we only have short extracts from Mr. Hopwood's report. Does the report say at the beginning whether he'd had access to the witness statements, in particular Mr. Cook's witness statement?
Yes, he had. I will check this point before confirming it absolutely. But yes, he certainly had, because I cross-examined him on the fact that he had quoted verbatim the parts of Mr. Cook's statement that he saw as benefiting the defendant's case. And he completely omitted to make any reference to Mr. Cook's evidence that he would have categorised the defect as category 1 and put a plate over it. I criticised him for that during the course of my cross-examination of him. So there's no question at all that he had, as one would expect an expert to have, he had access to the witness statements.
And you were allowed to cross-examine him on Mr. Cook's witness statement, but you weren't allowed to cross-examine the lay witnesses on Mr. Cook's witness statement. I'm trying to rely now on my recollection more than 2 years ago, and again this can be checked. Mr. Hopwood had put in large sections from the statement. And I can't remember now, my learned friend might remember. My learned friend might have said that they should be disregarded. Well, by that time, of course, yes, sorry, to put it all in sequence, by then I'd put the statement in. So.
You'd have had to have put the statement in by then, because the experts usually come after the lay witnesses.
Indeed, my lady, that reminds me precisely what happened. Yes, that was the sequence. At the end of, we called the lay evidence first, as it were, back to back, before we called any of the experts.
You then had the discussion about whether you could cross-examine the two lay witnesses on their views as to what Mr. Cook would have said if he'd been asked about it.
Yes.
And that led to you having to make the invidious decision to put in the witness statement without a formal ruling, and then we get the expert evidence, by which stage it's in warts and all.
My lady, precisely right. That's the sequence, absolutely. So by then it was in evidence. I did cross-examine him about his selective take from the report.
Take
from the witness statement.
Mr. Hopwood's evidence, the contents of his report, must surely have been influenced by what he read in the witness statements. Experts' reports usually are. Well,
indeed.
They're supplied with the witness statements of the principal players.
Yes. Well, yes. But he expressed, as your lordship's seen, as I set out, he formed the basis for the change in approach by the defendant at trial, once they'd appreciated they weren't going to call Mr. Cook, as Mr. Hopwood's idea that this was not a category 1, it was a category 2 defect, and his witnesses then fell into line with that. And the judge had forgotten, by the time he did his judgment, crafted his judgment, he'd forgotten that there'd been that change of case in the defendant's witnesses. So, look, as I said, my primary case is without the inspection, the 13th of February is irrelevant. One wouldn't look at the 13th of February anymore than one would look at the 13th of January or the 13th of April. It's only a relevant date if an inspection took place. And the respondent is only going to succeed in establishing the Section 58 defence if it shows that it's taken all reasonable steps. And it hasn't. We set out, I suspect Section 58 is well known to the court. We have it available at the beginning of the authorities tab if necessary. But without an inspection, without a walked inspection on the 13th of February, the Section 58 defence simply cannot get off the ground. But if I'm wrong about that, an inquiry into whether or not the hole was present on the 13th of February is nonetheless warranted, then, as I said, it's no good looking to the experts on highways, as the judge did. Because that, in turn, that seeks to explain how a hole that was not there, assumed not to be there in February, was there in April. So the judge should not have made any finding that the hole was not there on the 13th of February. I apologise for the double negative. I put it in that way because the burden of proof was obviously on the respondent.
Under Section 58.
Under Section 58.
Yes.
So, absent walked inspection, there's no longer any need for anyone to try and explain how they could possibly be in a hole missed by such an experienced inspector. So, well, that's the long and short of our case on Section 58. I'm quite keen to move on to the common law claim, which I'll try and deal with a little more briefly than I have this Section 58 point. If I'm wrong about Section 58, or just possibly if the respondent succeeds on his respondent's notice, claiming that the judge should not have found him as a dangerous defect at the time of the purported inspection, then I have the common law claim, and I accept, because it's absolutely clear from the authorities, that the Section 41 Highways Act duty does not extend to signage put up by a highway authority. But at the same time, that statutory duty does not exclude the possibility of a common law duty of care, not to do anything positive to endanger a highway user, and not to do anything positive encompasses also not to trap them in the broad sense of misleading them into doing something that they shouldn't be doing for their own and others' safety. Well, for that proposition, we rely on the House of Lords decision in Gorringe, quite a well-known case.
Yes.
That's in Authorities tab 11. Wake up my computer for a moment.
That is a signage case, isn't it?
It is indeed.
That's all about how the word slow wasn't what had been on the highway originally but wasn't there anymore.
Indeed, exactly. So, yes, the case, as my lords indicated, concerned a claim that the highway authority was liable to a motorist who'd driven into a bus in the absence of a slow warning sign on a difficult part of the road. There had been a slow sign there, but it had been removed with some resurfacing and not replaced. 5 speeches were given by their lordships that all agreed with each other, and in particular with Lord Brown, who we particularly rely upon as set out in our skeleton document. And we particularly rely on a part of his speech at page 200 of our tables, paragraph 102, in Lord Brown's judgment. Speech. Still the House of Lords at this point. Yeah. So 102, having set out the question and the conclusion that the highway authority is not responsible for omitting to put a sign, the slow sign on the highway. Lord Brown says at 102, what I've said thus far is in the context of road accidents involving negligence on the part of at least one of the road users involved. But that is because I find it difficult to contemplate a case in which a road accident could occur without such negligence unless either A, it results from the physical state of the road, in which case, as already explained, liability will in any event rest upon the highway authority, or B, the highway authority will, irrespective of any particular statutory power or duty, be liable in a conventional common law negligence action for having enticed the motorist to his fate by some positive act. Assuming the road user is not to be regarded as negligent, he must inevitably have been misled into ignoring whatever danger precipitated his accident. Although motorists are not entitled to be forewarned of the ordinary hazards of highway use, plainly they must not be trapped into danger. And then there's an important example we rely upon. If, for example, an authority were to signal a one-way street but omit to put no entry signs at the other end, it might well be found liable not because of any statutory power or duty to erect such signs, but rather because it induced the perfectly careful motorist into the path of danger, or assume road markings indicated where it's safe to overtake and where it is not, and that by some crass mistake in the painting of those, the motorist were to be ensnared into the path of an oncoming vehicle previously hidden in a blind spot ahead. That too would suggest to me misfeasance of the kind traditionally attracting tortious liability without the need to look for some statutory power or duty as its foundation. So, my Lord, this claim, come back to this action, it was originally brought on the basis that Mr Karpasitis was using a shared use path at the time of his accident, as he reasonably believed that he was. As I mentioned, the defendant, firstly, in ignorance of its own cycling map of the county, and then subsequently, notwithstanding its own cycling map of the cycling routes, recommended cycling routes in the county, said that this was a footway, and the judge found that it was indeed a footway. In other words, it was unlawful for cyclists to use it. And following from that, one would not expect a highway authority to exercise particular care for those cyclists who would inevitably, from a track of those dimensions, would inevitably have to go onto the grass verge to overtake other traffic, whether pedestrian or cycling, either in the same direction or the opposite direction. And that, of course, is precisely what the appellant was doing when he encountered the hole. He was overtaking a pedestrian.
You could say the same of another pedestrian, though, couldn't you? I mean, suppose you've got an elderly person walking down this relatively narrow footpath, and a jogger is coming up behind. Fairly graphic illustration that the jogger might want to give some birth to the elderly person and not to surprise them. Go round them.
Yes, indeed.
And therefore that would take them onto the grass verge. It doesn't have to be a cyclist. Or
No.
indeed a pedestrian could be taking evasive action from a cyclist coming in the other direction.
Yes, indeed.
Or the same direction.
Could be a pedestrian with a stroller or a pushchair. Yeah. And there are all sorts of reasons why ordinary traffic would encounter the grass verge. And the learned deputy judge, to be fair to him, did make that finding that there was nothing unnatural or improper about going on to the grass verge. But this is the point before that. On a clear basis that Mr Karpasitis told the judge, and the judge accepted, that he would never have been using that particular path if he'd appreciated it was not a path intended for cyclists. He would have found somewhere. He didn't have a particular destination in mind, as the evidence went. He was doing his permitted exercise during the early days of lockdown, so he would have gone somewhere more suitable if he'd been told, whether by signage or otherwise, that this is where the shared use path ends. It stops here. You now go back the way you came, or you go up the 2 flights of steps. But what you don't do is carry straight on.
Can you just make that good by reference to diagram or photos?
Yes, well, it goes back to what I was endeavouring to... You never quite have the photograph you want in these circumstances. Can I just say it's common ground that there was no end of cycle side. There was nothing to indicate, by way of signage, that the shared use path had become a pedestrian only path. There was nothing at all to indicate that.
Well, I understand that. That's the contention, right? I'd just like to see it physically on the maps.
Yes. Well, the cycling map is just simply not detailed enough.
No.
There are the pictures, of course, in our core bundle that we
Yes.
put in our skeleton argument. I've taken your lordship to those. I'm conscious that one of my own friend's witnesses, I think it was Mr. Alan Smith, was reliant upon a sign that was actually on the Paul Cully Bridge itself. I just wonder if that might satisfy your lordship.
Now, I'm not asking you to say, look, there is no sign here. I just want to see where on the photos the shared path ends.
Yes. Well, can we try tab 12 on A?
Yes.
I've been inundated with suggestions, but I think this might help start with. Tab 12 is the statement, as I said, of Mr.
Yes.
Smith. And he's taken, does your lordship recall, I took you to the cyclist dismount sign, which is intended for those who do a sharp right, where the photographer is at page 99. Where the only destination is up those steps. So what happens, and I'll deal with this in a moment, is that the path reduces in width by a factor of 2. And
Where?
I'm not sure then.
I think the real question is where, Mr. Porter. Where is there a photograph of it as it reduces?
Well, A99 is possibly the best one we have. Does your lordship see that there's a clear reduction in the width of the path?
Yes.
Yeah.
Yes.
That's it. That is where
And
it is
so
said the cycleway ends.
And which way are we looking in that?
We're looking north.
North.
Beg your pardon, my lord.
No, that's very clear.
Yeah. We're looking north, and the only option, as we set out in our schedule, the only option that the cyclist has when he arrives at this point is, obviously you can do a U-turn and go back the way you came, which may be fine if you're out for exercise, but it's not so fine if you're out to try and get somewhere. Or you can do a sharp right turn, past the cyclist dismount sign, and be faced with 2 flights of quite extensive steps.
Steps are off to the right of this picture, are they?
Just off to the right of that picture.
Just off to the right of A99.
Indeed. I'm just looking through to see if there's a...
Yes, that's the cyclist dismount sign, the blue one that's sort of on the side.
Yes, indeed. And my lady goes back to our skeleton argument.
In fact, that
We've
illustrates
tried to-
fairly nicely that the cyclist dismount sign is governing what's going off to the right-hand side rather than what's going on straight on.
Yes, indeed. Well, it certainly does. It was never contended by the
No.
defendants that governed
No.
anything other than traffic turning right at that point. And it's actually, I mean, interestingly, the circular bit of the sign has actually been removed between the time of the photograph, which we've reproduced at the top of the core bundle, page 41, and the time that Mr. Alan Smith has taken his photographs. But they're the same spot. It's suggested from behind me that A98 might help, and I'm not sure. Yes, I mean A98 gives you, if you were the photographer at A99 and you were to step backwards for 50 metres or so, I suspect, does your lordship see it? You can see in the same sign, the back of the sign that's intended for the southbound motoring traffic. You can see that in page A99. We turn back to A98, the bottom right photograph.
Yes.
It's just taken in the same direction, a little further
back.
south, and that you can just make out that turn to the right past the post on which there is a sign, cyclist dismount, which goes up onto that Paul Cully Bridge, which can just be made out at the top of the photograph. as I say, you've passed the point. You're some considerable way past the point at which you might have taken an unsigned right turn off the path in order to go anywhere else but those two options.
Thank you.
So there's some tension.
Mr. Porter, we're doing a slightly longer morning than usual, having started at 10. And,
Of course.
I think we'll take a break of a few minutes. If you've reached, as it were, the end of a paragraph, or at least a sentence, would that be a convenient moment to break off?
Yes, so long as I mark exactly where I am.
Yes.
Yes. Well, I've almost finished my submission, so maybe another 15 minutes before I hand over to my learned junior.
Yes. All right. We'll break off for 10 minutes. Yes.
What about the people?
What it's intended for.
Oh, good.
Yes, I saw that. Do you know what I think better is if you've got the original.
All rise in favour.
That's my pen. Oh, sorry. Sure, Mr. Weitzman can't be far.
No,
Or
that's,
Mr. Weston.
That's entirely our fault. We should have brought a clerk to look round, and I think we're just ahead of time.
I do apologise.
Sorry, Mr. Weitzman, my fault, not yours.
I thought I was still within 10 minutes. I
Yes,
do apologise.
you were.
We're so keen.
I can see from the judicial intervention.
We can't wait a moment longer to hear what Mr. Porter has to say next. Yes, Mr.
Well, Lord, I think if I recall correctly, I'd just been pointing out to the court the unusual arrangement of this admittedly cycle path and the way in which it terminated, according to the defendant's witnesses. As accepted by the judge, it terminated at that point where the path narrows, with no alternative for the cyclist other than to pick up his bicycle and go up the stairway. I mean, in the vast majority of cases, cycle infrastructure will end at some point where a cyclist is entitled to be, something that is shared with motorists typically. So there is obvious discouragement about over-littering with signs, but if there's ever any circumstance in which an end of cycle path sign is absolutely essential, it's where the path simply ends in a footpath, and the cyclist cannot reasonably know, unless he's a highways engineer, which Mr. Karpasitis is not, that he was doing anything wrong in carrying on further north alongside the A10. So the appellant was led, we say, by positive action from the highway authorities to believe that he was able lawfully and safely to carry on north from the Portcully Bridge, and that's what he did. Judge, I obviously cited Gorringe to do that, Deputy Judge, and he dealt with it in my submission in a way that makes no logical sense. That paragraph 145 of his judgment, this is tab 9 of the core bundle, page 112. So I'll go back earlier in that paragraph in a moment, but just to start with the end of it, where he refers to Lord Brown's example in Gorringe, he dismisses that with the words, "There are presumptive rules about not cycling on footpaths, absent express authorisation, which cyclists are taken to know." My Lord, in my submission, that's precisely like saying that in the example of Lord Brown, motorists know that they should not drive the wrong way up a one-way street. This is why the road user needs the information, because he knows that he shouldn't be cycling if it's not cycling infrastructure. The motorist knows he shouldn't be going up a street if it's one way in the opposite direction. It doesn't make any logical sense to dismiss the arguments based on Gorringe by saying there are presumptive rules about not cycling on footpaths.
Well, in layman's language, looking at the photos on A98, 99, when the path is wider and improved, it isn't going to be a problem in real life that you have both cyclists and pedestrians, or it shouldn't be, because
Yes, indeed.
you can overtake, you can two can pass, no problem. But once it narrows to single track and not very wide at that,
Yes.
then there is a problem.
Yes.
And there'd be, on the wide section, there'd be no reason for anyone to use the grass verge, but on the narrow section there is.
Yes, indeed, my Lord.
Yeah.
Your Lordship, I think, has my point that it's not safe. I mean, it's not just that there's a suggestion in my learned friend's skeleton argument that it's sort of coincidental that he was using that path and he went into a hole in the verge, because what matters, according to my learned friend, is he went onto the verge. But the point is, because he's on such a narrow piece of infrastructure that doesn't meet the relevant standards, but then a lot of infrastructure doesn't, particularly for cyclists. Because he's on that narrow path, it is then entirely likely, as the judge found, that pedestrians and cyclists will have to resort to the verge in order to pass each other. The evidence that the judge had before him was that the width of a facility is not a reliable guide as to its status. So, quite where the learned judge's observations at paragraph 147 of the page come from is not clear. At 147, the learned deputy judge says he accepts the defendant's submissions that the use of end signs is not mandatory and discourages the guidance. Nothing in the guidance requires an end sign at a point like this. The reduction in width of the path implies a change in character and of use. The absence of signs indicating shared use north of the Coulson Bridge implies the path is not shared use. There is therefore no liability in negligence. That, with respect to the learned deputy judge, completely misses the point. He made no findings of fault against the appellant for using that reduced width path. The appellant was never really challenged on his belief that it continued to be a shared use path rather than a pedestrian path. The absence of signs, it may be, derives from the judge's own flawed researches into Rule 13 of the Highway Code, which is, I'm sorry to jump around, it's back on the previous page at paragraph 144. Where he says the presumption in the Highway Code, which is relevant evidence if not determinative, is that a footway is just that, unless a marking or a sign expressly authorises cycling. The judge doesn't deal at all with the fact that there are signs further back which indicate expressly that this is a shared use path. And there's nothing, as it were, to cancel those signs as you carry on north. And it's right that a proliferation of signs is discouraged. So you wouldn't expect a sign on a dead straight path where nobody's joining or leaving. You wouldn't expect a proliferation of signs reminding people that they are on a cycle track rather than a pedestrian track. And even if there would be such a proliferation of signs, you couldn't expect the ordinary highway user to know from the absence of signs further up to the north that its status has changed. Query, well, where does it change? How far from the last sign does it change, and why? It clearly needs an end of cycle path sign.
Can I just ask you,
Yes.
When you referred us to paragraph 144 a moment ago,
Yes.
you described it as the judge's own researches.
Well, that's, yes, and I then rather lost my thread. It's entirely my fault. Because in fact, the judge was fine with the highway code that was in force at the time of this accident, which was just before the recent revisions.
But did 144 come from evidence, however loosely, or is this the judge's own work?
This is the judge looking up the highway code, getting the wrong edition, and section tab 5 in bundle A is the section that was current at the time, which I have a distinct recollection of supplying the learned deputy judge at the time. This is actually, because I think my learned friend was relying on it, this is actually an extract from the highway code relating to guidance to pedestrians. But that's by the by. Paragraph 13. This is what the highway code said at the time. I doubt there's anything to be gained by my reading it out to the court. See what it is. And it's not the same as the current version, which has been amended and which the judge plainly looked at. And I'm afraid I don't immediately have to hand the current version, but if the court wishes to see it, I'm sure we can arrange that. My learned friend has it. Oh, with copies. My learned friend obviously is coming to this. I wonder if I
Thank
could
you,
ask your
Mr.
assistance to just pass it up. Perhaps I better keep one.
Can I keep one of them?
So sorry. In fact, if we just pass up 3 copies, then I can. My own junior might need to. Well, I'm grateful to my own friend for having found the current one. And we think that his observations, paragraph 144, must come from the current version. I'm not sure even then it's quite as clear as the learned judge seems to put it. I suppose it's where signs indicate in the final paragraph. Some routes are shared. So where signs indicate is what has been latched onto by the learned deputy judge with his own researches into the highway code, which comprise the wrong edition. But I mean, be that as it may, it completely misses the point to say that cyclists know that they're not to cycle on footpaths, because that's why you need a sign to tell them it's a footpath rather than a cycleway.
Well, you say that may be so as a
Yes.
general proposition, but not obvious when you've been cycling along a wide, plainly shared pathway that suddenly narrows.
Yes.
And you're next to the A10.
Yes. Lord, exactly. The guidance says that end of cycle lane signs are not frequently required or always required. And obviously, in a circumstance where the path simply changes from shared use to pedestrian use only, there's got to be some indication. Otherwise, cyclists are, as the defendant admittedly knew well. The evidence at trial was very clear. They knew very well that this was a path that was frequently used by cyclists in ignorance of the prohibition. My Lord, again, showing some signs of this judgment being crafted at slightly different times, he makes similar points about the change in character of the path. He makes in paragraph 147. He makes them with further comments at 145, where he adds into the change in width of the path. He adds in undulations, as well as the lack of shared use signs. This is 145 in the middle of the paragraph. And he says that's sufficient to indicate to a reasonable cyclist that the path is no longer one which could be used for cycling. And frankly, well, that's flies in the face of common sense. The ordinary cyclist who has no knowledge of highway standards is supposed to go along a path that, for all intents and purposes, appears to be continuous, and then suddenly say to himself, oh, due to the fact the width is less and it's a bit undulating, I'm not allowed to cycle here. It's frankly unrealistic. It's a rosy view of cycling infrastructure in any event, as the cycling experts indicated, that cycling infrastructure doesn't ever contain undulations or is not ever narrower than it should be. We live in a real world where cycling infrastructure is often not quite up to scratch, but is still deemed by many cyclists to be rather better than cycling on the carriageway of the A10, which is the alternative if you wanted to go north from that point. So our submission is that this is very much covered by Lord Brown's example. It's as close perhaps as one can get to his example of the no entry sign. The positive layout of the shared use facility led the ordinary highway user, including Appellant, to believe that shared use extended north of the Portcully Bridge. As we've touched upon already, I don't want to repeat myself, it's inevitable that cyclists who are considerate of each other and of pedestrians and of buggies and the like will inevitably use the verge to pass. And the judge was quite correct to find that. And the respondent's notice criticising that is in my submission, unrealistic. We know Mr Karpasitis would not have used that path at at all, if he'd not been misled into thinking that he was entitled to do so. And what goes with entitlement to do so is that he'd be reasonably safe in doing so, so the local authority would have looked at the verge with cyclists in mind, which of course they didn't do. Well, at the beginning of the trial, the respondent wisely abandoned its claim that this was a danger created by somebody else, not them. They were pointing the finger at Broxburn Borough Council by way of a proposed amendment, but they abandoned that, and I note from my learned friend's skeleton argument that he accepts that this was an arrangement for which the highway authority was responsible. So it was a danger expressly created by them. They did not warn about it. And so far as local authority resources are concerned, it could hardly be easier to post an end of cycle path sign for the northbound traffic as well as that was turning sharply to the east. Well, those, unless I can assist further with that, those are my submissions on the common law claim. As anticipated, I'm going to invite my learned junior to delve a little more deeply into what went so wrong in the court below, where she was not present. Had she been, it might have all been ended differently, who knows. But she's now going to kindly address whether the appellant and or the judge were obliged to accept the truth of the whole of Mr. Cook's statement.
What do you have in mind about dealing with the respondent's notice points?
Oh, Lord, we've set out in, we hope, appropriate detail. It's not quite a skeleton. It's got a bit more flesh on it.
Yes.
Exactly what we think of the respondent's notice points.
Yes.
They weren't in our original skeleton argument because of the timing feature. We allowed an extension time. But I hope it's helpful that we set that out in writing. Having done that, I've got nothing really to add to what we've said in writing about those points. We don't, on this side of the court, consider them at all powerful, but I will, of course, need to reply to them when my learned friend has pressed them.
Yes.
So hence the half day that I'm hoping to have tomorrow afternoon, and I think we're on course, I think, to finish around about lunchtime, and hopefully my learned friend will be on course to finish by lunchtime tomorrow.
Right. Yes. Discuss that.
My lords, my lady, I have in summary 3 submissions to make to the court. The first is that my learned leader should have been permitted to cross-examine Mr Vine and Mr Alan Smith on what was a credibility issue based on parts of the statement of Mr Cook, and if necessary, the parts of Mr Cook's statement relating to the categorisation of the defect could and should have been admitted for that purpose, without requiring the admission of the entire statement. My second submission is that the appellant and the court should not be bound by Mr Cook's evidence that he conducted a walked inspection on the 13th of February 2020 as a result of having decided to put his statement in evidence. And my third submission is that when determining the facts, the judge ought to have appreciated that his acceptance of Mr Cook's evidence in relation to the categorisation of the defect should not preclude or inhibit him from finding that Mr Cook's statement was mistaken, or if necessary not truthful, in relation to the walked inspection. Turning first of all to my first submission about whether my learned leader should have been permitted to cross-examine on the credibility issue. In my submission, this is the point in the trial below where matters started to go terribly wrong. The transcript at which this came before the court for submissions is bundle B, tab 5. I'll try and maintain my words in my way into that. There was it's B126.
126.
Yes, my lord.
Thank you.
There was a short break after the cross-examination of Mr Alan Smith. The parties came back into court and counsel for the respondent said he had no further questions for Mr Alan Smith and that he could be released, and that is when Mr Porter said that he did have questions for Mr Alan Smith, and those were the questions about the credibility issue. If we turn over to page 127, where he says, I'm going to ask this witness, if I may, whether he knows how Mr Cook would have recorded the defect shown in the photographs. Leading counsel for the respondent objected to that. The learned judge's first instinct was to allow the question. You'll see it lines 7 to 9. I'm going to allow the question, and if you need to ask questions arising out of it, I'm going to allow you to. So that was the judge's first instinct. But then we can see as the submissions went on that the judge ended up taking a very different view. Although, as my lords and my lady pointed out before the short break, there was no formal ruling on whether the learned leader was permitted to put those questions.
Before we get there, Ms. Councillors, did Mr Alan Smith at that stage express the view as to what he thought Mr Cook would have, what category of defect Mr Cook would have put it into? The whole.
Yes, I know. Page reference. It begins at, it's in the same tab, beginning at B91.
Yes.
This is the cross-examination of Mr Alan Smith on the leader. And it runs through to B95 and it concludes at B95 lines 22 to 23 where he says that was Mr Cook, would still only have flagged it as a category 2 medium.
Page 95.
Yes, B95 is probably the clearest example. At line
From my
22.
knowledge of Jeff.
My apologies, my lord.
Yeah, from my knowledge of Jeff and my usual practice. Don't need category 1. We batch our category 1s. It's significant. I wouldn't be surprised to see him flag it as a specific location. He would still only have flagged it as Cat 2 medium. What's confusing me now is that this is during cross-examination.
It is, my lady, yes.
So, just so I can get my head clear as to the sequence of events, Mr Alan Smith comes in, he gives evidence in cross-examination already as to what he thinks Mr Cook would have categorised this hole as. Then he's re-examined, and then the argument about whether or not this point could be put comes after re-examination?
The submissions about whether the point can be put came after the re-examination by leading counsel for the respondent. So the cross-examination, if I can take my lady back to page B91,
right,
B90,
yes,
if I may, and it's line 18.
So the argument was basically over fresh re-examination, was it?
Cross-examination.
Cross-examination.
Cross-examination, my lady. Perhaps for context, I can take
Originally, yes, because originally the point is made it doesn't arise out of any questions the judge asked. That's
Yes.
1, 2, 7,
Right.
4, 5, 6, yeah.
I'm grateful.
But just noticing, Mr. Karpasitis, that page 91, the witness, before he's asked the detailed questions about category 1, category 2 and so on, the witness says at line 8, I appreciate you're uncomfortable with Jeff's evidence. I'm not quite sure why, but Jeff would have been able ... which suggests he had seen
Yeah.
Mr. Cook's statement.
That's correct, my lord. The The actual statement itself, if I may take the court to it, is in Bundle A, tab 12. And I'm looking in particular at paragraph 11 of Mr Alan Smith's statement.
Sorry, page reference again.
Page A83, Michael.
The one that we looked at this morning.
Yes. It's about halfway down the page, beginning, halfway down paragraph 11, beginning, I'm aware that Jeff has retired from Ringway. And he goes on to say, he was regarded as a very capable, conscientious, diligent and experienced highways inspector, having come across Jeff in the past, he struck me as an inspector who was able to properly risk assess defects and determine whether a repair was required. He was also able to distinguish between a Category 1 and a Category 2 defect, and did not tend to adopt a one-size-fits-all approach to his safety inspections. And the statement of Mr Cook very clearly said at paragraphs 9 and 10, which is pages A115 and A116 of the same bundle at tab 14, that he would have, if he had seen this hole, categorised it as Category 1. Now, similar comments also appeared in the statements of Mr Vine about Jeff Cook's evidence, and this is page A111, tab 13, paragraph 5, where Mr Vine said, halfway down that paragraph, I regarded him as one of, if not the most experienced and capable highways inspectors employed by Ringway. And then it says, further down, Jeff was very experienced and understood well HCC's requirements as set out in their inspection manual. Jeff knew when to intervene and raise a works order, and I cannot recall any occasion where concerns were raised about him missing a defect during any wards inspection. So looking at those three statements together, there was no challenge in the statements of Mr Vine and Mr Alan Smith to Mr Cook's written evidence that if he had seen the hole on the 13th of February 2020, he would have categorised it as Category 1. That, in my submission, was a very clear impression, and certainly the impression my learned reader had when cross-examining Mr Alan Smith.
Well, that explains why Mr Poulter asked the questions that he did at B90, starting at line 20.
Exactly, my lord. And there, as my Lord Justice Coulson pointed out, Mr Alan Smith then went off on a tangent at B91, saying, I have every confidence that Jeff was a very experienced inspector, and I think, had he not retired and be off enjoying himself, which he's perfectly entitled to do, he would definitely have been here to explain the statement himself. My learned leader then says, I didn't ask you about any of that, Mr Smith. And then he goes on, I appreciate you're uncomfortable with Jeff's evidence. I'm not quite sure why, but Jeff would have been able. And then Mr Porter says, I want your evidence if you wouldn't mind. And then he says, you're picking on Jeff's evidence. That's why I'm a little confused. And as my Lord Justice Coulson pointed out, this witness clearly knew about the existence of Mr Cook's statement when he gave that evidence. And if it wasn't clear enough, which in my submission it was in relation to, from that line of cross-examination, my learned leader ensured the point was put later on when he was recalled for cross-examination at tab 5B144.
So now we're back. This is the judge. So
this is after the statement of Mr Cook was admitted, and Mr Alan Smith was recalled to answer questions, having been put into the position of having to decide whether to admit Mr Cook's statement. That's what my learned leader did, and then there was further cross-examination of Mr Alan Smith. And at line 16, the question is, you've given evidence that Mr Cook was experienced inspector who well knew the difference between Category 1 and Category 2 defects. He says yes. The question, you made those comments in your statement in knowledge of what Mr Cook was saying, and the answer was yes. So an acceptance there explicitly by this witness that he was aware of Mr Cook's evidence at the time when he sought to say for the first time in oral evidence that Mr Cook would have categorised the defect as category 2 instead of category 1. And at page 16, same page, yes. My lead quite rightly points out at the top of that page, B144, you see there's a statement from Mr Jeff Cook. Answer, I do, yes.
Yeah.
Question, have you read that with the statement before?
Yeah, but not
I have, but not recently.
Well, presumably when everybody was making their witness statements.
Yes. The likelihood is, my lord, that Mr Vine would also have been aware of Mr Cook's evidence. So that is the context in which that evidence came about, and in those circumstances, in my submission, the only fair and just approach would have been to permit my learned leader to cross-examine both Mr Alan Smith and Mr Vine on those parts of Mr Cook's statement in which he gave different evidence about to Mr Vine and Mr Alan Smith's all evidence about the categorisation of the defect. And unfortunately, he was not permitted to do so, and that is where this trial, unfortunately, started to unravel, and where things started to go terribly wrong procedurally. There are a number of features, aside from the fact that, that on the credibility issue, that is a matter that the appellant ought to have been permitted to cross-examine on. There are particular features in this case which support the submission that the appellant ought to have been permitted to put parts of Mr Cook's statement to those two witnesses. The statement had been served of Mr Cook along with the other witness statements. The Civil Evidence Act notice in relation to Mr Cook's evidence was served shortly before trial on the 24th of February 2023, and that is apparent from the notice itself. We then get the new evidence, as I have said, during oral evidence of those two witnesses, which came as a surprise to the appellant, particularly given that was not evidence that they'd given before. And those witnesses gave that evidence in the knowledge that Mr Cook was not going to be called. It was the respondent's choice not to call Mr Cook to give evidence. The statement of Mr Cook was available, and indeed had formed part of the parties' respective preparations for trial. The appellant didn't know that he wasn't going to be called until a short break during the trial itself. But in the circumstances, there could be no prejudice to the respondent by permitting cross-examination of those two witnesses based on parts of Mr Cook's statement. They knew what the evidence was. That was evidence that they themselves wanted to rely upon until the short break, one of the short breaks during the trial.
But in relation to Mr Alan Smith, sorry to interrupt you, but in relation to Mr Alan Smith, he was cross-examined on Mr Cook's, this part of Mr Cook's statement. I appreciate there are separate points about whether that meant he was your witness and whether you were bound. I get all that, and you're coming on to that. But just on that point, you said he should have been allowed to cross-examine on the Category 1, Category 2 point and what Mr Cook said about it. But he was, wasn't he?
Yes, my lord, but I perhaps should have been clearer. That should have been permitted without having to put the whole statement.
It happened after the whole witness statement
Yes.
went in. In other words, the sequence, as I understand it, is the witness says something unexpected, which you've got ammunition you've got that you want to be able to use to challenge it. There's then a debate as to whether you're allowed to use that without having to put in the whole of the witness statement. You lose that argument. The whole of the witness statement then goes in with all the consequences that flow from that. And after that, the witness is cross-examined. Is that right?
That's correct, my lady.
Yes.
Cool.
So the problem is the consequences, as it were, not of the cross-examination on this particular point, at least of Mr Alan Smith, because he was cross-examined on it. The problem is the wider ramifications of the statement going in.
Yes, and what effect does that have on the appellant?
And what about Mr Vine? Had he already given evidence?
He had already given evidence, and that the point of evidence where he does that is at bundle B, pages 71 and 72. So he gave that evidence before Mr Alan Smith did, but he wasn't recalled to be cross-examined on both parts of Mr Cook's statement, even after the statement of Mr Cook was admitted into evidence. And then the leader says that the witness had actually gone after he gave evidence, so he wasn't there to be recalled. decision, although there was no express ruling, and I'll take my lords and my lady to that part of the transcript in a moment, but not permitting the appellant to put those parts of Mr Cook's statement to the witnesses without putting the entire statement in was deeply prejudicial to the appellant, and was, as I say, the moment when this trial unfortunately began to unravel in a way that's deeply unfortunate. My learned leader did express his concerns about not being permitted to do that. This is the transcript at B130, and this is in the context of the submissions that were made to the court about whether or not the appellant should be permitted to cross-examine those witnesses. My learned leader says at line 23 at page B130 that a completely misleading impression has been given to your lordship that the highways inspector would have categorised this defect as category 2, and that was the concern. There was this evidence available which was directly contrary to the oral evidence that had been given to the court by these two witnesses, and the effect of the respondent's submission was to exclude that evidence from the court's consideration when determining what was a key part of the case. So despite the judge's initial reaction to permit my learned leader to put the questions, there was objection by the respondent, whose line of submissions in summary was that if the appellant wanted to do that, they would have to put the statement in, and in order to do that, they would have to put the entire statement in. Where we get to is that there is no formal ruling on whether or not my learned leader was permitted to put that, those questions without putting the statement in, but that is implicit in the submissions, particularly at pages B140 and B141. And my learned leader ends his submissions at line 18 by saying we are significantly hampered in the prosecution of our case because of his last-minute absence. The learned judge says, well, if you can't cross-examine, and that is Mr Cook, then that's obviously a factor going to weight. And the learned leader says yes, and the judge says if the statement is in, and then the judge says at B141 from line 21, he asks Mr Weitzman if he has any objection to my learned leader taking instructions on whether to rely on Mr Cook's statement, and if he obtains instructions that he does not want to rely on it, that he seeks to admit it under 32.5. Mr Weitzman says, I can't object to that. The rules allow him to do that. We served it, he could admit it. I will have submissions on the effect of him choosing to rely on that evidence, but we'll get there later. So there is no formal ruling that my learned leader was not permitted to cross-examine without putting the statement in, but that is in effect what happened. It's an implicit ruling, that, but no formal ruling, which in my submission there probably ought to have been. There is then a short break, and at the bottom of page B142, we can see that my learned leader says, my lord, thank you very much for your time. I do have instructions to put statements of Mr Jeff Cook into evidence with all the caveats that I expressed before, but obviously I'm not accepting the content of the statement. And then Mr Alan Smith is recalled to be cross-examined. So my submission, the judge's failure to permit the appellant to put parts of Mr Cook's statement to the other witnesses in cross-examination is an error. That was a fundamental error, and in my submission, in and of itself, is sufficient to overturn the judgment. My Lady Justice Andrews expressed concern about the evidence that was given by these two witnesses, and I say with very good justification, because the evidence of Mr Cook was as the highways inspector who had conducted the inspection, and his evidence on that part of the case was what in his judgment he would have done if he had seen the whole. The witnesses, Mr Alan Smith and Mr Vine, gave that evidence in my submission out of context. Mr Vine was employed by Ringway as a contract manager, and Mr Alan Smith again was a manager with a very long qualification, which he sets out at page 8.
Yes, but are you actually accepting that it was within their remit to give this evidence at all? I mean, that they are being asked, or rather they're volunteering, what they think somebody else would have done if they'd seen something that that person claimed they didn't see.
My lady, I share your concerns, and
Yes.
that evidence is not admissible evidence in my submission.
Well, then perhaps Mr. Porter ought to have submitted to the trial judge that he could ignore it altogether.
My lady, yes, I do see that point.
But anyway,
suspect
you
it
say
was
that the
rather-
damage was done because they were allowed to give it, and in the heat of the moment, counsel, faced with that position, has then got to say, well, they've said something, the judge is in danger of being misled, because they say, we know Jeff, we've known him for 20 years, he's wonderful, he's a very experienced man, and he could only possibly have classified this as a category 2 defect, and you've got a piece of information which the judge hasn't yet seen, which says exactly what Mr. Cook would have said, which is a category 1.
Exactly.
And faced with that, you say, well, no competent counsel in that situation is going to leave that stone unturned because the judge is otherwise going to be in danger of being misled.
Exactly. In the
Yes.
position that Malana Leader was put into, there was no
difficult.
choice. There was no choice but to decide to put a statement in.
Yes.
As my lady quite rightly
Well, he was
said, the
between a
damage
rock and a hard place at that stage.
Exactly. The damage had already been done. But one can see from the submissions in relation to that it was a very fraught moment in the trial.
Yeah.
It was obviously quite heated, and in my submission, in those circumstances, one can quite see why my learned leader didn't say to the judge, well, actually, you should exclude that evidence entirely, given what was happening in the trial at that
Well,
moment.
we've got to be very careful not to look at these things through the glasses of hindsight.
Yes, it is always easier
Yes.
to look at it with hindsight than in the heat of the moment during a trial. Insofar as is necessary, and I appreciate that it is a decision of the High Court, the case of Chapman, which is at tab 22 of the bundle of authorities, is an example, and I put it no more as an example, of a case in which a judge had actually permitted the admission of parts of the statement of the witness. That the defendant in that case had sought to rely upon in closing. And I really have 2 points. One is that it shouldn't have been necessary to admit paragraphs 9 and 10 of Mr. Cook's evidence at all in order to be able to cross-examine on those points. They were at the very least a document in the case that we were permitted to cross-examine on. But so far as the court is satisfied that actually those paragraphs needed to be admitted into evidence, in my submission it was within the court's power to do that. And the case of Chapman at tab 22, pages 390 to 391 of the bundle of authorities at paragraphs 43 and 45, is an example of the court doing that. I appreciate in different circumstances, but it is an example of the court admitting parts of the statement, which is something that the respondent says that the court cannot do. We say that the court does have the power to do that in the particular circumstances that the court found itself here.
Well, the hurdle you have to surmount, as I understand Mr. Weitzman says, it was necessary. The judge was right to rule, in effect, by indication, that except by putting in and accepting the whole of Mr. Cook's witness statement, with perhaps a small discount for the fact that he wasn't physically present to be cross-examined, you couldn't even refer the witness to part of his signed statement.
We submit that Mr. Weitzman, with respect, is not correct about that.
Well, you have to deal with the decision of this court in property finance.
Yes, and I will go on to deal with that. But
Right.
But broadly, before I come to that, in a situation where the challenge that the appellant wanted to make at trial was a challenge on the issue of credibility, we don't get to the point where a decision has to be made about the admission of a statement, because on an issue of credibility, and that was the only reason that the appellant wanted to refer the witnesses to that statement, to basically say, look, you knew about this statement when you gave that evidence, and you gave inconsistent evidence knowing of the existence of that statement, that those particular circumstances in my submission meant that there was no need to put my learned leader into the situation where he had to make a decision about admitting or not admitting the entirety of the statement. And so I say that there's an answer to that before we even get to that point.
In relation to Chapman, obviously the part dealing with this particular point is short, and Mrs. Justice Hill rightly explains why those particular bits are relevant. But there's no suggestion there, I think, that there are other parts of the statement which are controversial or which are contrary to the case of the party putting it in. In other words, it doesn't seem on all fours with this, and I noticed that property alliance isn't referred to.
I do appreciate that there are limitations to the example because no case can be exactly the same. The court will need to look at each case on its own facts, and there was an agreement in that case about the admission of those. So perhaps there's not as much detail in the judgment as there might otherwise be if there had been a dispute. But it is merely, I say, an example of the court exercising its power to admit only parts of the statement. If it was necessary to do that, but my primary submission was that it wasn't necessary to admit even parts of that statement because all that the appellant wanted to do, I say all because it was actually something critical, but what they wanted to do was cross-examine on the issue of credibility, and in order to do that, it wasn't necessary to even admit those parts of the statement, but just to be permitted to put those parts of the statement to those witnesses in cross-examination. If the court's not with me on that first submission, then we do get to the point, if the court is satisfied that actually the question was, should the appellant put in the statement or not, and then the decision is made that they are going to put it in, whether the appellant and the court should be bound by that statement, having made the decision to put it in. We only get to that submission if my lords and my lady were against me in relation to my first submission. But if you're not, then in my submission, the appellant and the court are not bound by Mr Cook's evidence that he conducted a walked inspection. If I may, I'd like to address you on that point. The key part of the judgment here is paragraph 136, which is the core bundle at page 111. Tab 9. Now I invite the court to read paragraph 136.
So, despite the double negative in the last sentence, that's as close as you come to a finding that he did inspect.
Yes, there was. Let me just check my notes.
Because we've seen those other paragraphs where the judge seemed to be trying to make the finding without reference to Mr Cook's statement.
Yes, there is also paragraph 133 of the judgment.
Yeah.
Where there is also reference to Mr Cook's evidence.
Yeah.
All of which postdates the judge's finding without reference to Mr Cook that the hole was probably not present on that day. It's almost a topsy-turvy analysis, isn't it? Because
it is.
You get to Mr Cook after the event, and then the judge discounts the immediate contemporaneous document which suggests that he didn't carry out that type of inspection and therefore wouldn't have seen the hole even if it was there.
That is in my submission, a sign of what Lord Justice Males pointed out when giving permission to appeal at page 16, the same bundle at tab 2, that the judgment does show some signs of having been prepared at different times, so that I'm afraid the delay did feed in at that point, because there are, as I would go on to demonstrate, I hope in the course of my submissions, examples of how the delay has affected the judge's reasoning, and that my lady, is, as you quite rightly pointed out, actually isn't an example of that.
Yeah.
Mr. Cook's witness statement didn't refer to the GPS document.
It didn't, no, and we say that it ought to have done, because there was an email at bundle A at the last page behind tab 25.
Yes, Mr. Porter showed us that earlier.
Which
Take
clearly
that
says,
with A32.
yes, that clearly says that Mr. Cook's statement will give evidence about the duration of the walked inspection start and end points, and then mysteriously he doesn't deal with that in his statement at all. So it's quite clear on the face of that email in my submission that the respondent was aware that there was an issue with the GPS data, hence that carefully drafted email in which they said that Mr. Cook could address it. When it comes to the witness statements, they don't do that. There's the appellant that anticipates that they'll have an opportunity to cross-examine him on that. Civil evidence that notice is served out of time shortly before trial, and then a decision is made during the trial not even to rely on his written evidence.
Yeah.
So looking at paragraph 136 of the judgment at page 111, in summary, the judge found that the appellant could not use the GPS evidence to challenge Mr. Cook's evidence that he conducted a walked inspection. Now, the judge had formed the view, having accepted the respondent's submission on this, that he was not permitted to do that. That, in my submission, is an error of law, and the property alliance case, which coincidentally both parties rely upon, actually demonstrates in my submission that that the appellant was permitted to challenge Mr. Cook's evidence based on the GPS data, and that the court could therefore have made that finding. So it is the property alliance case at tab 20 of the authorities document. Page 355. This is a decision of the Court of Appeal. And looking at paragraph 170, one can see that the issue in the property alliance case was whether the judge was right to decline to allow a party to rely on passages from the witness statement of a witness which it contended supported its case, the statement having been served by the opposing party, but that witness not having given evidence at trial. So that was what was being decided in the case of property alliance. Not whether a party was permitted to put parts of a statement to a witness during cross-examination, or whether parts of the evidence could be rejected. But as part of that, at paragraph 172, the court did consider the case of McPhillamy. Now, the decision in McPhillamy, so far as I can tell, the full decision was not before this court at first instance, in our case. Nor was a copy of the Filiatria legacy, both of which are key decisions in relation to the question as to whether the appellant should be bound by the evidence. The summary of McPhillamy in property alliance, and this may have fed into the judge's error in relation to this, simply cites a section of Lord Justice Brooks' judgment at D on page 356. I know of no principle of the law of evidence by which a party may put in evidence a written statement of a witness knowing that his evidence conflicts to a substantial degree with the case he is seeking to place before the jury, on the basis that he will straight away say in the witness's absence that the jury should disbelieve as untrue a substantial part of that evidence. Now, in my submission, the meaning of that paragraph is that you can't put a statement in and then say, but you shouldn't accept that because that witness is lying, that witness is mistaken. It doesn't describe a situation where there is actually evidence to support that submission. and evidence that you're utilising in order to persuade the court that that witness is mistaken or lying. And in my submission, there is clear authority which demonstrates that the appellant was permitted to challenge Mr Cook's evidence that he conducted a walked inspection as being mistaken by relying on the GPS data. And
why does it make a difference in principle if there is evidence to support the fact that the witness is lying? Because as a matter of principle, isn't it right that you can't approbate and reprobate? You call your witness on the basis that they are being put forward as a witness of truth. If you then try to adduce before the fact finder evidence which contradicts part of their witness statement, you're putting them forward not as a reliable witness or a witness of truth. It doesn't matter whether it's supported or not.
I suspect, my lady, although it's not entirely clear from that short paragraph, the judgment that's extracted at D on page 356, whether that was the point that Brooke LJ was getting to in that paragraph.
Well, he was very familiar with the filiatra legacy, so I would have thought it probably was.
Yes, so that appears to be a reference to the point that my lady's just made.
I mean, that's the point. We have to drill down to matters of basic principle.
Yes.
I can see the force of your argument that as a matter of principle, CPR 32.5 has nothing to do with the question of whether you can put a point to a witness in cross-examination which arises from a witness statement that's not being relied on by the other side without having to put the full statement in. I get the force of that completely, subject to anything that the other side have to say. I can see where you're coming from there. But once you get past that and you're forced to make the choice to put in the evidence, then I don't see on what principle basis you should be allowed to cherry pick.
If I may answer my lady's question by taking you first of all to the filiatra legacy, which is at tab 3 of the bundle, and if I could ask the court to turn to page 40.
Yeah.
And this is the left-hand column.
Hang on.
Apologies, my lady.
No, don't worry. I've just post-it notes vital. So
It's page 40, tab 3.
page
Bundle
40, tab
authorities.
3.
And this is the filiatra legacy.
Yeah, no, I know that. Page 40. Yeah.
And it's left-hand column, 5 lines down from the bottom of the page, beginning in one category. In one category are the situations where a party says that his own witness is giving mistaken, albeit honest evidence, and where he seeks to establish this either by calling direct evidence to contradict what his witness has said, or by arguing that when the evidence is regarded as a whole, a mistake is to be inferred. We believe that this is a common occurrence in civil litigation and unobjectionable in principle, provided that care is taken to avoid surprise and hence injustice. And there seems to have been an approach at first instance in this case of saying, well, it's as simple as was Mr Cook lying or not. Well, I say that it's not that. The first question is, was he mistaken in his evidence that he conducted a walked inspection? Another alternative is, was he lying about that? But the first and perhaps less controversial approach is to consider whether or not Mr Cook was mistaken about his evidence that he had conducted a walked inspection. And it's quite clear, based on the filiatra legacy we submit, that actually you are entitled to look at the issue as to whether a witness's evidence is mistaken, and that is something that occurs very commonly in civil cases. And that, in my submission, is also supported by the case of McPhillamy, which is at tab 7.
Sorry, just before we leave the filiatra legacy, can you just say again which paragraphs of the long red sidelined passage you rely on?
Yes, my lord, in relation to this particular point, I will come back to the filiatra if I may, but on this particular point, it's the left-hand column beginning in one category are the situations where a party says, which is about 4 lines from the bottom of the page.
Page 40.
Page 40, yeah, 40. It's internal page 361 of the judgment. It's paragraph beginning returning to the first proposition, we have received interesting arguments.
Okay.
Up to the end of that, of the paragraph, which ends on the right-hand column, but there are more parts of the filiatra that I will take my lord to. But I just wanted to take it issue by issue, if I may.
So you say that supports the proposition, and indeed what Lord Justice Mustle goes on to say supports the proposition that if you want to say that certain of the evidence is inaccurate because there is a contemporaneous document that shows it's inaccurate, and therefore must be mistaken, but you're not impugning their integrity or their honesty, you can do that.
Yes, my lord. And if I may move on to the case of McPhillany, that is a further example of the same point. This is tab 7 of the bundle of authorities at page 120. And at F on page 120, the court refers to the case of Ewer versus Ambrose, 1825, which is in fact one of the cases that the respondent relies upon. And if I can ask my lords and my lady to read F to G on that page, which is the quote from Ewer and Ambrose. That paragraph ends with the words, "He may show by other evidence that he is mistaken as to the fact which he is called to prove." So there is in my submission clear authority in both the filiatra legacy and also the case of McPhillany and Ewer versus Ambrose that the appellant was permitted to show by other evidence, in this case the GPS data, that Mr Cook was mistaken in relation to his evidence that he conducted a warts inspection. Now, the respondent accepts this as a principle, and that's apparent from their skeleton argument. If we look at the core bundle at page 64, which is tab 6, paragraph 12, where they say in the first line, while it is entitled to call other evidence that may provide a different or inconsistent picture. Well, that is key. That's an acceptance in my submission of the propositions I've just addressed the court on. They accept that as a matter of principle, the appellant was entitled to call other evidence or use other evidence that provided a different or inconsistent picture. And also at paragraph 15 of the skeleton argument, at page 65, where they say, although by reference to other evidence in the case, they might submit that he was mistaken. And that is the third and fourth line before they cite the filiatra legacy. Given their acceptance that is permissible as a matter of law, it is then somewhat surprising that the inconsistent submission is made at paragraph 19 of their skeleton argument at 66, relying on the Property Alliance Group, that the appellant was not in a position to rely on the GPS data to impugn Mr Cook's evidence. So,
well, that's presumably on the hypothesis that it's impugning it on the basis that he must be lying.
well, if, and I will go on to address my lady and my lords in relation to that, it's not clear whether they're distinguishing between the two. If that is the distinction, then that is a separate point which I will address the court on. But it's very clear that they accept that we're entitled to invite the court to find that Mr Cook was mistaken in relation to the water inspection based upon the GPS data. Insofar as is necessary, I've taken the court to the case of Burnett versus Lynch, which is at tab 16 of the authorities bundle, which simply makes the obvious point that judges are confronted daily with the unexceptional possibility of accepting or rejecting part of the same witness's evidence. That seems to me is an obvious point of principle. So there's nothing difficult or wrong in the court perhaps accepting part of Mr Cook's evidence, namely the part where he says, if I had seen this hole, I would have categorised it as a category 1 urgent defect. But on the other hand, rejecting his evidence that he conducted a water inspection. And there would have been nothing in principle, we say, with the judge taking that approach in his judgment.
So which paragraph of Burnett?
It's paragraph 23, my lord, at page 276 of the bundle of authorities, tab 16.
Paragraph 23.
Paragraph 23, yes. That leads on to the next question.
I recognise that paragraph, and I'm trying to think why, and I suddenly remember this is an appeal from Judge Gosnell in Leeds, and he was very proud of that paragraph. Yeah.
My lord, my lady, that leads on to the next question, which my lady Justice Andrews alluded to, which is what was the appellant permitted to challenge the evidence of Mr Cook as being untrue, as distinct from being mistaken? And at first instance, the respondent's submission was that this was not permitted, and they relied on the Property Alliance case. And their position was that it was a matter of settled law at first instance. There was no suggestion that this was a difficult question for the court to decide. They simply relied upon the case of Property Alliance and the extract of McPhillamy in the Property Alliance case and said, well, no, Judge, you are not permitted to do this. A different position has been taken in the skeleton argument in relation to this appeal, because what they say at paragraph 18 of their skeleton argument, and this is page 66 of the core bundle at paragraph 18, they say at the beginning of that paragraph, there is no case precisely on point. Now that is not the impression of the submission that was given to the court at first instance. It was a very clear, Judge, you're not permitted to do this. In my submission, in our submission...
You're not. You cannot allow question to be put to Mr Alan Smith based on something said in Mr Cook's signed witness statement without putting in the whole of the witness statement.
That was effectively the ruling that was implicitly made. But the next question, once you've decided to put that statement in, is the party putting that statement in permitted to say, I've put the statement of Mr Cook in, but I'm inviting the court to find that in relation to Mr Cook's evidence that he conducted a water inspection, he was lying about that. So the respondent's submission at first instance was, you cannot, as a matter of principle, put the statement of Mr Cook in and then go on to say, but he's lying. And there's now an acceptance by the respondent, actually, that they don't consider that the point is settled as a matter of law as to whether you are permitted to put the statement of a witness in this case Mr Cook, and then say, but but my lord, I invite you to find that he was lying as to whether or not he'd done a water inspection.
Well, the point was left open expressly in the filiatra legacy, but it was left open on the basis that, on the facts of that case, it was singularly unfair to the witness, because the witness was not given an opportunity. It was never given any advance warning that anybody would be saying that he was lying about, in that case, the inspection that he carried out. And it would have been grossly unfair to have made that submission without the opportunity for him to come and answer for himself. That's as I understand the filiatra legacy, but it's a long time since I last looked at it.
My lady's preempted my submission, because in response to the question, was the appellant permitted to challenge the evidence of Mr Cook in relation to whether he conducted the warts inspection as untrue? In my submission, the answer is yes, because this was not a serious allegation against Mr Cook, like the allegation that was being made against Captain Bellucci in the filiatra legacy. And even if the court were to find that the appellant was not permitted to challenge the truthfulness of that part of Mr Cook's evidence, that he conducted a warts inspection, in my submission there's a distinction to be drawn in any event between any such restriction upon the appellant and any such restriction upon the judge. And it's very clear in the filiatra legacy, as I will go on to take my lady and my lords too, that there is no such restriction upon the judge, and that was accepted by the court in the filiatra legacy. So if I may take you back to the filiatra
Sorry,
legacy.
just so that I'm clear, do you need to go that far? Are you impugning Mr Cook's credibility and saying he's lying, or are you saying that it was a long time ago, he's mistaken?
My lord, exactly. Our primary point is that it's not necessary to go that far. That
Right, okay.
the likelihood is that he was mistaken, and I've already taken my lords and my lady to the authorities that demonstrate that we were permitted to make the submission that the witness was mistaken.
Okay, so
but in the alternative, if you're not with me in relation to that, then I say, if we are in the position where the only option that we have is to impugn his evidence on the basis that it was untrue, then I say we were permitted to do that for the reasons I would like to explore based upon the filiatra legacy.
The trouble with the mistaken theory is the timing. So the witness doesn't finalise his witness statement. The GPS material comes up at a time when you're told by the solicitors that his witness statement will deal with it. One has to assume that he's then shown the GPS, or should have been shown the GPS information, and he doesn't either correct or withdraw his statement. I suppose we're speculating to a certain extent, because there's always the possibility that they couldn't get hold of him to deal with it, but it all does seem a bit rum because of the timing. I mean, if the GPS evidence had come up months after he'd signed his witness statement and it had been exchanged in the normal way, then it doesn't have quite the same whiff about it. But the fact that you get this letter from the solicitors that's sent by email which says he's going to deal with it, and we've got an explanation for it, and then his witness statement goes in unamended, and then they decide not to call it. Puts you in rather a difficult position saying he's mistaken, doesn't it?
Well, the basis upon which we say there's likely to be a mistake, my lady, is that when one looks at the actual documents of the inspection, which is the only contemporaneous record of the inspection, which is exhibited to Mr Cook's statement, and that is in tab 14,
Yes.
it doesn't actually record.
That it was
doesn't
walked.
actually record whether it was walked or not.
Yeah.
So
Isn't that the critical point? You know, you don't have to. You wouldn't have had to go so far as to say you were never in the area at all. And the suggestion that you were is plainly untrue. The GPS evidence, which the judge rejected, certainly suggests his car was in the area, and it drove from Cheshunt along the A10 and back to the depot over about 20 minutes, during which it stopped once for 3 minutes, which suggests that there was either no walking inspection or a drive during which he stopped and maybe got out of the car once, and that was it. But since he didn't say in his witness statement that he had conducted a walking inspection, you didn't have to show that he was lying, did you?
Well, that's the perhaps the first submission is that he was mistaken, and there is, in my submission, a reasonable basis, and that is the conclusion that the judge ought to have reached, that he was mistaken. But if he had to go so far as to say that he was lying, first of all, we say he was permitted to do that, and there was sufficient evidence to do that based upon the GPS data. But in relation to the point as to whether he was mistaken, the only contemporaneous record of the inspection at page A122 doesn't say that the inspection was walked, and when it comes to the statement itself, which begins at A113, it's obvious on a proper reading of that statement that this person doesn't have any independent recollection of having conducted this inspection. Now, that's not surprising given the number of inspections he conducts, but it's very obvious from the wording of the statement that he's got no recollection of having conducted the inspection. If we look at paragraph 3 at page A114, for example, he says at paragraph 3, second line, I carried out a walked scheduled inspection of both the footpath and the adjacent grass verge on 13th of February 2020. Now, he doesn't say how he comes to remember that, because there's no contemporaneous record of that. And then he talks in terms of what he would have done, not what he actually did. For example, halfway down that paragraph, I would drive to a particular location. A few lines further down, I would drive to the starting point. Paragraph 4, I would have parked my vehicle. So what he's describing is what he usually does, not what he actually did on the date in question. And so there is no evidence to support, apart from the blatant reference to say, evidence to say, I carried out a walked inspection. There's nothing to support that, not even his own recollection or any contemporaneous documents. That's before we even get to the GPS data. Coupled with the GPS data, very clearly in my submission, the finding should have been, at first instance, that Mr Cook's evidence that he conducted a walked inspection was mistaken. There is no need for the court to go so far as to say that he was lying, but if it was necessary to do that, in my submission, it is clear that he was, but it's not necessary to go that far. But if it was necessary, then we say we were permitted as a point of principle to make that submission if it was even necessary for the court to go that far. And my Lord Justice Coulson makes a good point, because in the Filiatra legacy, the court didn't need to go that far and said that it wouldn't go that far. And that's precisely what should have happened in this case at first instance. That the court didn't need to go so far as to consider that, and it was looking at it through the question through that lens which caused the judge to fall into error, because when he was looking at the judgment, he didn't entertain or consider the possibility that actually this witness might just be mistaken, which is part and parcel of usual arguments in civil cases.
Well, it's worse for you because he disregarded the GPS material altogether.
He did.
Treated that as inadmissible evidence, effectively.
Which was, in my submission, a mistake.
Yeah.
So, may I take the court back to the Filiatra legacy just to demonstrate why the court in this particular situation should have permitted the appellant to challenge the evidence of Mr Cook as being untrue. Going back to tab 3 of the vulnerable authorities. Beginning at page 40, which is the page I took the court to a moment ago. And if I may take the court to the right-hand column, the paragraph beginning, what we do not find in the authorities and works of reference, and if I can ask you to read up until the end of that paragraph on the next page would be rare indeed.
So that's where you get your
Yeah.
point on the distinction between what is permissible for a party and what is within the power of the judge.
Yes, my lord. And that is a point that's acknowledged by the respondent in their skeleton, in the core bundle at page 65, where they say the position of the party was to be distinguished from that of the judge, who had a discretion to make a finding that the witness's evidence was untrue, if otherwise the remainder of the evidence would make no sense. So they accept that, even though their position is that the appellant was not in a position to challenge Mr Cook's evidence on the basis that it was untrue, they do acknowledge that there is no such restriction on the judge in those circumstances. And looking at page 41 of the Filiatra legacy, left-hand column, the paragraph beginning "in these circumstances we do not find." I may ask the court to read that paragraph, and then the next paragraph immediately below it.
Yes.
So the court there was saying they don't consider the judge is not able to make a finding of dishonesty, or that the evidence was not truthful. They didn't consider that that was the result of the authorities. But then they go on to say, when we think about the practicalities of that, there are certain features of the case, and particularly of Captain Bellucci, that caused them some concern. And in the case of Captain Bellucci, there were two possible explanations for his evidence, and they're set out at subparagraph D in the right-hand column on page 41, both of which were very serious. So that the two possible motives for lying were identified as realising he had allowed his employers to be defrauded of $1 million. He lied to cover up and went on to do so until the trial. Or the other possible motive was that he was a dishonest man who pretended that he had carried out the inspection because he was part of the conspiracy to steal. In the present case, our case, the potential explanations are, as I've already identified, that Mr Cook was mistaken as to whether he had done a walked or driven inspection, and or that he had lied about whether he'd done a walked inspection because he knew that he should have actually done a walked inspection. This is very far in my submission from the potential motives for Captain Bellucci's lies in the Filiatra legacy, and doing a driven rather than a walked inspection is not in and of itself a criminal offence. There are no serious consequences in my submission. Mr Cook is no longer an employee of Ringway, retired. There are no implications for his future employment. If he had lied in his statement and he'd given that evidence also on oath, then potentially that would have been a contempt of court if there was a finding that he was lying. But that is a situation in my submission faced by the court on a daily basis when assessing whether a witness is lying or not. And the concerns in the Filiatra legacy were about what were described as very serious allegations in relation to Captain Bellucci's involvement. So because of those concerns, where the court got to in the Filiatra legacy is at page 42 of the bundle, just under subparagraph G in the left-hand column, the paragraph beginning "we believe." If I could invite the court to read that paragraph up to the paragraph that is actually marked. The only fair result that the court considered should have occurred in the filiatory legacy, if such a finding was to be made, was to allow Captain Bellucci to hear his credibility put into question and to defend it in person. That is not a situation which is applicable here in my submission for the following reasons. The GPS data was not new evidence, which came as a surprise to the respondent, or would have come as a surprise to Mr Cook if he pretended to give oral evidence. They knew about the existence of that GPS data before Mr Cook prepared a statement, and indeed they'd indicated their intention to address it in the witness statement. The question of the accuracy of that data and its potential significance in this case was in my submission known to the respondent, and that's apparent from the email that they sent disclosing it. Mr Cook had the opportunity to address the GPS data in his witness statement, and he didn't take that opportunity. Indeed, the respondent had informed the appellant that this would be addressed, and no explanation has ever been given as to why that did not happen. So, unlike Captain Bellucci, Mr Cook has had the opportunity to address what on the face of it clearly looks like problematic GPS data, which calls into question whether he had conducted a water inspection or not. So, in the present case, we submit that the appellant was able to challenge the truthfulness of Mr Cook's evidence that he conducted a water inspection based upon the GPS data, and the court has my learned leader's submissions as to the GPS data itself. But the court also has the indication given by Lord Justice Males when giving permission to appeal in the core bundle at tab 16, and it is obvious from the reasons that were given giving permission that it was clear to the court that there was something terribly wrong with that GPS data. If we look at paragraph 3 on page 16 of the court bundle, where Lord Justice Males said, however, Mr Cook's stated reason for declining to give oral evidence was feeble, and the contemporary records, which are otherwise unexplained on their face, appear to show that his evidence was not true. So that GPS data in my submission very clearly demonstrates that the witness, Mr Cook, had not conducted a water inspection. I'm mindful of the time, and I haven't yet reached the end of my submission. I'm just wondering what before I move on to a different issue, whether...
Well, I think it's probably better that we stop now, and I said at the start that we would, in any event, give your side a few minutes tomorrow morning, even if you had thought you hadn't finished. How much longer do you think it will be?
I think I've dealt with the main points. I think I maybe have another, hesitate when giving council's time estimates, but maybe another 20 minutes.
All right. Well, that still gives us enough time.
My apologies for not finishing.
No, it's fine. I think we'll stop now and resume at 10 o'clock tomorrow.
Court rise, please.